read the briefs, we're familiar with the record, we have conferenced the case. Please keep that in mind as you make your arguments here. As you approach the podium, please identify yourself and your clients for us. We are recording these proceedings, both audio and by video. And when the videos are completed, they'll be uploaded to YouTube, and you can watch them at your convenience at some point in time. With that, counsel, you may proceed.
Thank you, Your Honor. May it please the court, Ivy Kushner on behalf of the appellants, and I do wish to reserve 5 minutes for rebuttal. We have 3 issues set forth in our brief, 2 of which relate to issues concerning a failure by the plaintiff to establish its burden of proof, both as to damages and the contractual prerequisite of a default letter. The appellate process certainly is designed to safeguard against errors by the trial court, but is not a process for the litigant to get a do-over or correct or supplement its evidence at trial. Through the course of the brief, there were challenges by the appellant, foundation challenges to Mr. Cox's, their primary witness, to testify as to certain issues and exhibits. Those objections were overruled by Judge Flores. What we now find, as you see through the course of the appellate stage of this process, the plaintiff has withdrawn or amended its position as it relates to 2 elements of its damage claim: its refusal to credit the payments that were made through the bankruptcy court, as well as the damages that were by plaintiff identified as attorney's fees associated with the bankruptcy proceeding, which, as of last week, they identified as late charges. And that was our whole point, that this witness could not testify relating to these figures.
Counsel, let me just ask you.
Yeah.
With that supplemental filing last week, Wells Fargo withdrew its request for the $62,000.
Yes.
So that's really not an issue anymore, right?
Well, the number isn't the issue, but the underlying problem that this witness, that they submitted evidence for which a witness was not qualified to testify about, and it just processed through, reinforces why foundation and qualification of a witness is a fundamental issue. But
Hold on
sorry,
just a
Your
minute.
Honor.
Counsel, let me walk through this with you.
Yes.
When I read the record, as I understand it, you didn't object to Mr. Cox testifying about the principal balance. You didn't. It's not your position that he was unqualified to testify about the principal amount, correct?
I did acknowledge, and I don't dispute that today, Your Honor, that Mr. Cox possessed the knowledge to testify about the principal balance. The problem is he never did.
I understand you disagree about what the sufficiency of the evidence in terms of the amount. And likewise, he had the foundation to testify as to the accrued interest, although I know you don't believe there was sufficient evidence to support the amount awarded by the trial court. You're not objecting to either or you're not objecting Mr. Cox's competency as a witness to testify as to those 2 items, right?
I am not, Your Honor. I concede that was within the purview of his knowledge.
And now with the $62,000 gone from the judgment, the only other item that's left from the trial court's judgment is this category of quote unquote other loan fees and costs for $7,474. Correct?
I agree with that, Your Honor.
So my question is, when I looked at your brief, your opening brief and your reply brief, I never saw where you addressed that item of damages in terms of insufficiency of evidence to support it. Can you show me in your opening brief or your reply brief where you addressed the $7,474 award for other loan fees and costs?
I believe that related to the property inspection, though this is a problem that's pervasing this case, that the numbers don't jive.
And let me tell you where I'm coming from with my question. I certainly saw the discussion about the $62,838.67 damage award in the trial court's judgment. That's been withdrawn. I don't see anywhere, I looked, I couldn't see anything in your opening brief or your reply brief where you argued this $7,474 amount wasn't supported by the evidence.
Page 10 of the opening brief, I do reference the portion of the record where Mr. Cox was asked, who did you pay the property inspection fees to? I was not part of ordering the property inspection, so I couldn't attest to that. I don't know.
All right, counsel, I read that, but you've challenged this damage award. You've challenged the judgment also in terms of liability. I understand that. As an appellate judge, I don't know how to address whether or not you're challenging the $7,474 amount. I know there's a disagreement about the principal balance. I know there's a disagreement then about the accrued interest. And the only other item of damage that I'm left with is $7,474, and I can't find anything in your brief that raises a specific argument as to the problem with that amount. I know there was some testimony about different items, appraisals. I think there was a $44,000 figure regarding appraisals. And so, again, I'm asking you, was there anything that you can show me in your brief where you identified what the problem was with that item of damages and why there was insufficient evidence as that in your brief?
Okay. Because the plaintiff's witness didn't provide figures for that either, it's difficult to coordinate the reference to the property inspection with the specific dollar amount, but as I indicated, without belaboring the point, Your Honor, the only item that by plaintiff's presentation corresponds to the property inspection dollar-wise is the
Counsel, all I was looking for is anywhere in the brief that says the $7,474 award of damages is not supported by the record. And I don't see that argument in your brief anywhere.
My point is that there was a foundation objection to Mr. Cox testifying about the property inspection, and we challenge the fact that the judge overruled that objection.
Okay. Let me ask you another question. In terms of the bankruptcy payments, as I understand it now, those payments have been credited. Is your argument that would have reduced the principal amount or the accrued interest or both?
Both, Your Honor. That Mr. Wright testified that since the bankruptcy filing, the principal amount was reduced by approximately $500,000. What we understand is that the plaintiff is contending that there's default interest being charged to the guarantors as opposed to the interest rate that the court set in the bankruptcy court. So I think their position is going to be the math doesn't change. But the note talks about, and the guarantee talks about the guarantors assuming the indebtedness of the borrower. And currently the indebtedness of the borrower is what was ordered in the bankruptcy court per the plan.
Okay. Do you contest this default interest rate of 8.5% per annum? Do you believe that the record lacks support for that interest rate?
For a basis to assert that the guarantors, that interest should be accruing at a rate different for the guarantors than under the terms of the plan.
And what do you believe the correct interest rate should have been, based on the evidence?
What we submitted, the one of the exhibits was the bankruptcy plan, and Your Honor, from my recollection, and I'll stand corrected, I believe it's 3.5, but I don't have that figure right in front of me in my notes.
Is that trial exhibit 48?
Yes, Your Honor. The Judge Gould and other members of the court, I think you grasp that our point is, as it relates to the damage issue, that a trial witness capable of providing that evidence is who and what is required to sustain a damage award. And throughout the course of their own brief, and this should be a tremendous red flag, that their own witnesses testified about amounts different than the amounts Mr. Supple said he believed that the principal amount was 23.1. But again, and most importantly, Mr. Cox never testified. He was called back on rebuttal, and he never testified as to what the principal amount was.
Where did your client come up with the number? In the record, your client testified that he thought the Wells Fargo number was $23,622,000. He thought the principal balance was $23,602,000. Can you cite me to anything in the record where your client would have known that Wells Fargo was seeking $23,622,000?
No, Your Honor.
But your client believed that it was $23,602,000. That was his testimony.
He did testify to that, Your Honor, but as to what he relied on to provide that figure, I could not tell you.
So would you then be conceding, if we took your client's number, that the principal balance was $23,602,000?
No, because I don't know that that number's accurate.
But can't the court rely on testimony from your client as well as Wells Fargo in determining the amount of damages?
Well, the case law, and this is conceded by plaintiff in their brief, that when a damage issue is subject to precise calculation, mathematical calculation, then that is what the standard is. And there, either through Mr. Wright or through the plaintiff, there isn't anything in evidence that satisfies the that standard in terms of how the figure of the principal balance was derived or the accuracy of that figure. And if Judge Flores is saying, as she said in her minute entry, much to my surprise, that Mr. Wright lacked credibility, then that is also another consideration as it relates to just plugging in a figure unsupported by any underlying calculations.
I'm sorry.
I was going to say,
You can ask a question about this because I was going to move on to the next issue.
I was just going to ask, even if the judge decided that your client was incredible, could she have still adopted his number of 23,604,000?
But she didn't.
Well, but could she have done that?
As the trier of fact, she
The trier
could
of
have.
fact. Okay, thank you. Yep.
And so my question, counsel, was moving on to the next issue of the validity of the notice of default.
Yes.
Can you share with us whatever point you'd like to make before?
What happened here, Your Honor, is that the plaintiff showed up apparently assuming that they did not need the actual default notice, and they take the position, since we didn't actually challenge it in the joint pretrial, then they had no obligation to satisfy that prerequisite that was set forth in the guarantee.
Wasn't the fact of default actually stipulated to in the pretrial statement?
No, Your Honor. Throughout this proceeding, when you send a default notice, you're saying you owe the money. The guarantors have never conceded that they are obligated under the terms of the guarantee. What was stipulated to is that they signed the guarantee, and what was also stipulated,
They signed the guarantee, but it doesn't apply to them? I'm misunderstanding.
they signed the guarantee, Your Honor, and for the reasons set forth in our estoppel argument, that they claim they were not obligated in the context of this claim to pay under the terms of the guarantee. And what happened here
So
was...
is it your position that this estoppel argument negates, well, let me state it this way. Your clients received a notice of default, but it's somehow been superseded by this estoppel argument if, in fact, the trial court bought it?
Well, my client, neither Mr. Wright nor Mr. Herlihy specifically said, I remember receiving a notice of default. Neither one of them testified to that. And the plaintiff didn't bring in a witness, even as the judge, they were on the third day of trial seeking to admit this exhibit. They didn't bring in the author of that exhibit. And it's incredible to believe that the plaintiff thought that the party stipulated that notice was given, because if you look at the sequence of the explanations, the first explanation was they didn't raise it in their pretrial, so we didn't think we had to bring it. The second explanation was we thought it was sufficient for Mr. Supple to simply testify that the notice was sent. And then on the third day of trial is when they bring up this issue of we thought it was stipulated to in the joint pretrial. And that's a strained interpretation. So I think with the 2 minutes I have left, I'll defer to plaintiff.
Thank you, counsel.
Thank you, Your Honors. May it please the Court, Brian Howie for Plaintiff Appellee Wells Fargo Bank. This dispute arises from the failure to repay a loan made by Wells Fargo to a sophisticated commercial real estate developer for the purposes of constructing a 3-building design center in Scottsdale Air Park.
Counsel, let me ask you a question. You sent us a demonstrative exhibit.
Yes, Your Honor.
February 29th. I can recognize some of the numbers in here, others I can't. Looks like the principal balance is the same as was awarded in the judgment, the accrued interest is the same, and then there's a whole host of other numbers in there. What's the point of including all these different numbers now in this demonstrative exhibit?
The point, Your Honor, is to provide some context and focus for what transpired below. When Wells Fargo at the trial had Mr. Cox testifying, it prepared for him a damages summary. That is the very demonstrative exhibit that the court has today.
So this is the document that's been talked about that he was looking at.
The little piece of paper that's referred to in the briefs. It is, Your Honor.
This was never marked as an exhibit for the record, was it?
It was not marked as an exhibit. It was not admitted into evidence. It was used for Mr. Cox to refresh his recollection, and consistent with the rules on refreshing recollection, it was provided to Guarantor's counsel in advance of trial. The trial court judge had a copy. Mr. Cox obviously had a copy on the witness stand. Everyone in the courtroom was literally working off the same page. And I thought it would be helpful for the court to see that damages summary for purposes of understanding what's been referred to in the brief as this little piece of paper. Now, in the damages issue, I'd like to start with what the parties do agree on. The parties agree on the standard of review, abuse of discretion. The parties agree that this money was loaned to Loop 76 and was not paid back. The parties agree that the guarantors have failed to fulfill their obligations under the guarantee. The parties also agree that the amount of principal that is owed to Wells Fargo is $23.6 million. As Your Honor has already alluded to in questions directed to Guarantor's counsel, Mr. Wright testified in his direct that he thought the principal balance was $23,604 and that Wells Fargo's was $23,622.
Counsel, I have to ask you a question about
Yes.
that because it's a large number. I read the record.
Yes.
And it is a little confusing in terms of the precise number. Mr. Cox never testifies to that number. The loan documents are introduced into evidence. Is your client hanging its hat on the testimony of Mr. Wright to establish this amount?
Not solely, Your Honor. Obviously, let me address one point, too, that you asked. You asked where Mr. Wright had come up with the $23,604 figure. That was the amount of principal that was due and owing to Wells Fargo at the time of its summary judgment motions, which were filed in September 2010 and July 2011. You'll see the principal figure in the motion itself is it's a little under $23,604. The damages award can be affirmed for two reasons. One is based on the evidence that is in the evidentiary record, Mr. Wright's testimony, the third modification agreement and demand letter, which set forth those are Exhibits 50 and Exhibits 20. Those set forth the amount of principal owed as $23,039,524.19. The testimony of Mr. Supel, who said that the principal balance owed to Wells Fargo was $23.1 million. Mr. Cox did not testify as to the specific principal amount of $23,622, but he did testify as to the total amount that was owed. If you look at his...
I guess I'm confused a little bit as to why Mr. Cox, who was responsible for handling the loan, although I think somebody else came in later on, was it Mr. Supple?
Mr. Supel, that's correct, Your Honor.
Excuse me. Why they couldn't look at a printout as to what the current balance was that day or that month and come in and testify. I've reviewed the business records in this case, and it's $23,622. That never happened, though.
And the reason it didn't happen, Your Honor, was it was an oversight on the part of Wells Fargo's trial counsel. The intent was always to have Mr. Cox read off this demonstrative exhibit, was to have him read off all these figures. What happened was, through oversight, only the total amount was read into the record and not the specific components. Mr. Cox was prepared to testify, and this was not a case where Wells Fargo came into trial with a witness that simply, as you just alluded to, had no idea what the principal was or hadn't looked at the business records. In fact, this damages summary, this document that was provided to guarantors ahead of trial, was prepared based on the business records, and this was the amount. These were the amounts that were due and owing to Wells Fargo at the time of the trial in 2012.
And this principal amount was in the post-trial brief for Wells Fargo.
It was in the closing. Yes, Your Honor. What I did here was essentially replicate the damages summary by taking the identical content of what's on page 2 of the closing brief, Index of Record 107, and put it into a Word document. But this is the same document that Mr. Cox would have had at trial, and this is the document that Judge Flores would have had before her at trial as well. And so our contention is that the damages award can be affirmed based on what is in the record, the evidentiary record, as well as the fact that we know that this document was before the trial court, and everybody, the principal and interest figures are not, they're not in dispute. The interest figure, at least, is not in dispute from the standpoint of how the interest is calculated. There was evidence in the testimony that interest was accruing at the default interest rate, that the default interest rate was 8.25%.
I understand, counsel. Let me switch gears on you for a
Yes.
second, okay? The payments that were made by Loop 76 in the bankruptcy proceeding, I reviewed your arguments about why that wouldn't, or why that shouldn't be included or be offset against the sums that are owed by the guarantors in this case. Those payments had been made prior to trial by Loop 76
That's correct.
to Wells Fargo. Is that right?
That's correct.
I know subsequently they've been credited against the account. You'd held them in a suspense account at the time of the trial. Wouldn't that be a windfall to your client to allow Loop 76 to make payments as the principal in this case, or under these loan documents? You hold those payments, get a judgment for the full amount, and then after the fact, credit those amounts against the interest and possibly the principal? But why would you be allowed to do that? I mean, the case law is pretty clear that if a principal makes payments against the underlying obligation, then those payments should be credited as to any obligation by the guarantor. The guarantor's obligation is derivative of what the principal owes.
A couple of points, Your Honor. First of all, the payments that were made by Loop 76 in bankruptcy were made pursuant to a plan that supplanted the note, the note that the borrower had signed. The guarantee is a separate obligation. It's a separate contract between the guarantors and Wells Fargo. And the bankruptcy code, 11 U.S.C. 524E, is clear that the bankruptcy court doesn't have the power to alter the obligation between the lender, Wells Fargo, and a guarantor such as the individual guarantors here. So any readjustment or reorganization of what the borrower, Loop 76's personal obligation under the note was, that has no preclusive or binding effect, can't modify in any way what the guarantors are obligated to pay. The guarantors are obligated to pay on the face of the guarantee a defined term called the indebtedness, and that is all of the amounts that the borrower was due and owing under the loan documents.
Counsel,
And
if Loop 76 had discharged the entire loan in bankruptcy, had paid the entire loan off, are you telling me that the guarantors would still be obligated on the separate guarantee?
there will never be a double recovery, Your Honor.
No, that's not my question. You would agree that if the guarantors if Loop 76 had discharged the entire loan, that the guarantors would also be discharged?
No,
if Loop 76 had paid off the entire loan to Wells Fargo, so there was a zero balance, the guarantors wouldn't be obligated to pay anything to your client.
the only clarification I want to get, Your Honor, is when you say discharge the entire loan, what the borrower is repaying in bankruptcy is what the plan requires it to repay. It's a restructuring of what the borrower's personal obligation. So when you say
paying the creditor, which is your client.
they are, Your Honor, and the other point I wanted to make is those plan payments are still subject to disgorgement. If and when the plan payments become final, right, if and when the Ninth Circuit affirms the plan, there will be a credit for the plan payments made. But Guarantors Counsel is suggesting that the allocation of principal and interest on what is being paid in bankruptcy is somehow binding on the allocation of principal and interest in the guarantee. And that's what I'm saying. The bankruptcy code and bankruptcy case law precludes the bankruptcy court from doing that.
Right. So it may be that these payments would go just to the interest.
And that is exactly the case, Your Honor. The accrued interest to date, as of the time of trial, accrued interest was $6.8 million. Now, to date, between December 4th, 2012 and today, that's another 519 days. Accrued interest is now at 8.25. We're at the $9.6 million. The amount of monies received by Wells Fargo from bankruptcy and from enforcement proceedings against the guarantors is far less than that accrued interest. So we haven't even paid off accrued interest, and therefore the amount of principal that the guarantors owe remains $23,622,423.82. Not a penny of that principal has been paid off. At best, those payments come near, but not that near, to paying the accrued interest. But the problem is, the reason the trial court didn't give the guarantors a credit for those payments is that the payments were still subject to being disgorged. In the bankruptcy proceeding, Wells Fargo appealed the confirmation of the plan. The BAP affirmed. Wells Fargo took that case to the Ninth Circuit, and it was just argued last month on April 7th. One of the things that may happen in the Ninth Circuit is that if the Ninth Circuit vacates the confirmation of the plan, one of the conditions on remand may be that the bankruptcy court says to Wells Fargo, you need to refund all of the monies you've received pursuant to the plan. And Wells Fargo is on record in the Ninth Circuit, both at oral argument and in its briefs, as saying, we're prepared to write a check and pay back every dime if that's what the bankruptcy court requires. If the trial court had credited the guarantors for that $3.5 million in payments, and then the Ninth Circuit vacated and the bankruptcy court required those monies to be refunded, it's the guarantors that would have gotten a windfall, because the judgment would no longer be correct. The judgment would reflect a credit for monies that Wells Fargo no longer had, and Wells Fargo would have to go back into court and amend the judgment. The other point I want to make on the bankruptcy payments, Your Honor, is that this is not an issue. The bankruptcy payments were held in suspense account at the time of trial because of what was happening on appeal in the bankruptcy proceeding. We didn't want to be put in a position where we would be accused. Depending on how the monies were held by Wells Fargo, the borrower could make an argument that the appeal was moot, that it should be dismissed on the grounds of equitable mootness. At the time, after this judgment was entered, the facts and circumstances changed. Enough time had transpired, and Wells Fargo said, we're going to go ahead and apply the payment. Now, Your Honor used the term credit, but by apply, all I mean is that the monies were no longer held in suspense. They were, Wells Fargo essentially had taken in those monies. Your Honor also asked about whether that would yield a windfall for the guarantors, and my response to that is, given the amounts that remain due and owing, as between the equities, Wells Fargo is still owed $23.6 million in principal, still owed probably nearly $2 million in accrued interest. So as between the balance of equities between the two, the equities favor Wells Fargo. And the guarantors will get a credit for these payments if and when those payments become final, just like any judgment debtor gets to go into court and say, the face amount of the judgment is this, but I've paid all these other monies. In a garnishment, I'm going to say in a garnishment proceeding, the judgment debtor is entitled to come prove that. The judgment debtor doesn't get an amended judgment every time a payment's made, and a judgment creditor isn't required to get an amended judgment every time it receives a payment.
All right, but just to be clear, your client was paid, or excuse me, Loop 76 was paid $3.5 million under the bankruptcy plan prior to the entry of this judgment, and your argument is that the guarantor should get zero credit for any of that $3.5 million as against either the principal or the accrued interest under the judgment. Is that what your argument is?
That's my argument, is that the trial court correctly said that we didn't have to credit them until the plan was final. It is correct that as of the time of trial, and that was Mr. Cox's testimony, was we've received $3.5 million. The other thing to keep in mind, as I said, we've only recovered less than $16,000 from the guarantors in enforcement proceedings. So this is not a situation where the total amount of the judgment, we're now nearing it with the combined total of monies received from the guarantors in enforcement proceedings and plan payments. We're nowhere close to that. As I mentioned, we're not even close to have paid off, having the accrued interest been paid off. Now, with respect to the notice issue, as Your Honors observed, there's really two points here. One is, was the notice given, and one, were the exhibits properly admitted. Our contention was that the notice was given. All that was required under the guarantee was to send the notice to the addresses listed on the signature pages, and that was in fact done. Mr. Wright and Mr. Herlihy both authenticated their wives' signatures on the return receipt cards. Mr. Wright authenticated his wife's signature after having denied just 3 seconds earlier that he lived at that address. Guarantors claim that the exhibits should not have been admitted because they weren't listed in the pretrial, but the parties had essentially stipulated to the fact that a demand had been made and not honored. There was certainly nothing in the pretrial that indicated that that was a contested issue.
When you say the parties had essentially stipulated, I'm not sure what you mean.
Well, the pretrial statement, subsection 1, 9, paragraph 9, notwithstanding Wells Fargo's demand for payment, guarantors have not paid Wells Fargo any amounts owed by borrower to Wells Fargo under the loan documents.
And I don't have it in front of me. Was that an uncontested statement of
I'm sorry, Your
fact?
Honor, I should have been clearer on that. Yes, that was a stipulation of material fact and law.
So in your view, an acknowledgement that demand had been provided.
That's right. That was we pointed to that to explain why the notice, the demand letters weren't listed as exhibits. Obviously, the trial court has broad discretion to allow a party to use an exhibit that isn't listed. We contend in this case that there was no abuse of that discretion. Certainly, there was no prejudice or unfair surprise. Guarantors had challenged the notice issue in a prior summary judgment motion, and the demand letters had been attached as an exhibit to the reply. So that was years early. That was 2 years ahead of trial. So the guarantors had seen these documents before, and obviously the guarantors had received them. And so our contention is there was no abuse of discretion in allowing Wells Fargo to use those exhibits and also to admit them into evidence once the guarantors had authenticated the signatures. With respect to estoppel, Your Honor, I'm content to rest on the briefs that we filed unless Your Honors have any questions for me on the estoppel defense. Thank you, Your Honor.
Ms. Kushner.
With the very brief time left, as to the uncontested statement that a demand had been made, that is correct, that Exhibit 16 was a letter dated August 25th, 2008, which preceded one of the modifications. So indeed, a demand had been made. There was nothing in the uncontested statement of facts that as to the claim default in 2009 that notice was given. The fundamental problem, Your Honors, is that the plaintiff is relying on their closing statement. That's not a document that is part of the evidentiary record for the basis to correlate the amount that is set forth in the judgment. You've heard a lot of different numbers today, and the role of this court, I would respectfully submit, is not to be recalculating evidentiary issues that were properly before the trial court. Why should this court now be asked to pick and choose, if you were to consider doing that, which of the 4 or 5 different principal amounts are in the record is the one that is the right number? And for that reason, and including the interest issue, the judgment is erroneous on its face. Thank you.
Thank you, counsel. Appreciate the arguments presented here this morning. We'll take this matter under advisement and we'll issue a ruling in due course. We're going to take a short recess to allow counsel for the next case to come forward and get set up for the argument. Thank you.
Nice to meet you. Good job.
That's all right. All right, thank you. Not sure if you would have heard me with the prior case, we had an issue with. Right.
Clients tend to